Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 224 of the NCDWI Guy podcast. On today's episode, I have special guest Warren Hynson joining the podcast. Warren concentrates his practice in criminal appeals and post-conviction relief. He handles cases all over the state, as he shared on the podcast, from Clay all the way out to Clay County in Western North Carolina, all the way out to the Outer Banks. I'm not even going to try to remember what the northernmost county is, Currituck maybe. But all across the state, Warren is handling post-conviction relief and criminal appeal matters. I got a chance to reconnect with Warren a couple of months back at the NCAJ convention in Wilmington, and Warren's conversation really sparked a thought process of having somebody come on the podcast to explain some of the considerations for appeal, advice for clients considering an appeal, ways to improve your practice in the courtroom that will help with a appeal ultimately being successful. And I think a lot of Warren's suggestions about how to kind of be preparing your case for an appeal actually make you a better trial lawyer as well. And so we'll get into some of those topics today. If you have any questions about an appeal, just give Warren a call. He is very open with his practice and sharing information with the criminal defense bar. He is passionate about what he does. So check out his website, Hynson, Hynson Law, HynsonLaw.com. His email and phone number are there. He is more than happy to talk you through any questions that you have about the appeals process or your particular case. So please reach out to Warren. Really enjoyed this conversation with Warren and hope you do the same. Well, Warren, it has been cool getting to reconnect with you here after the NCAJ convention, where we got to kind of share some stories and then have a follow-up conversation after that. So been fun to kind of reconnect. We were just reminiscing, and I won't include the client's name, but reminiscing about a shared client that was our initial point of contact. And this dude was a total character. So it was actually making me laugh, thinking back on this client that was one that you represented on appeal. But super excited to have you on the podcast and share some ways that we can improve preservation of issues as a trial lawyer, understand what kind of methods there are for relief on appeal. So super grateful to have you come on and share your wisdom with the audience.
Yeah, Jake, thanks for having me. It's good to see you. And yeah, it's always good to catch up. So happy to talk through these issues, and hopefully we can lay the groundwork across the state for some better possibilities on appeal.
Sweet. Well, yeah, I think, maybe a good place to start in terms of before we kind of dive into the substance of, kind of different appeal issues or tactics is just kind of, how did you get into the world of criminal appeals? It's definitely, somewhat of a specialized space to be in. So how did you get into that space?
Yeah, it's a great question. I would say the roots go back to law school and, really getting interested in the sort of constitutional dimensions of criminal law, criminal procedure. But then, connecting on summer internships with folks that did criminal appeals and did post-conviction work. And one summer in particular, I was down in Montgomery, Alabama, and I was working at the Federal Defender's Office, which worked closely as well with the Equal Justice Initiative and Brian Stevenson. And we were doing a lot of appeals and post-conviction work. And, maybe I'm just a nerd, but I just really loved the research, the writing aspects of it. And so when I finished law school and uh, started practicing, I knew that was something that I wanted to continue. So connected and with the North Carolina Appellate Defender and went through some trainings, got on their roster to do indigent criminal appeals. And from there, it kind of grew into incorporating a private appellate practice as well. I still do the indigent appeals, but then also adding in post-conviction and doing motions for appropriate relief. And we can talk more about sort of the differences of those. But yeah, I would say, it was sort of a good combination of just getting that exposure in law school and sort of hitting the ground running in North Carolina, and just fortunate to let that flourish.
Yeah, no, that's awesome. I mean, for me, that was really one of the highlights of law school. We did, like a moot court, like most first year students do. I think our like class for that was called lawyering process at Charlotte School of Law. And then, did appellate advocacy first semester of second year, did moot court for second and third year. And it was really like third year of law school doing I think it was called the Jessup Moot Court Competition, which was up in Seton Hall. That was a criminal-based question. The first year we had done like an international law competition. Then the second year we did a criminal law question. And I did the brief writing, so I didn't do the arguing, but just like piecing things together in the brief and really diving deep into the legal issues was a blast. And now I don't do any of that. Like I very rarely like write anything. So it's funny to like have the kind of focus point, so far askew from like what the like really favorite part to me of law school was, which was those moot court competitions. But yeah, that was really kind of what got me interested in criminal law, was that moot court competition, and writing the brief for that was just so interesting.
Yeah, yeah. And I think criminal law is so fascinating, and what we do as defense attorneys, because intellectually it's so engaging. I think the constitutional dimensions of what we do are so important, but intellectually fascinating, combined with the actual tangible impact that you can change a person's life, and
Yeah,
the fact that you can
100%.
do, that your constitutional issues are your means to helping someone. To me, it's just a great combination of interest and advocacy. So it was a natural draw for me.
Yeah, that's awesome. I mean, yeah, you definitely can change people's lives. And I think it's cool. I was kind of asking, what the client contact was with our shared client, from several years back. And you said that you got to talk to him on the phone. It's something that is, somewhat of an interesting perspective to hear what the communication is with a client by an appellate defender, because it seems so much removed from the courtroom, but it's cool to hear that there's still like that kind of client contact going on.
Yeah, it's definitely different than the trial lawyer's point of contact with the client, and that by the time, particularly if they're in state prison in DAC custody, it's mostly by letter. It's
Yeah,
really old
yeah,
fashioned.
yeah,
We're really corresponding by hand. They're sending me handwritten letters. I'm responding with typed letters. Um, a lot of that is because phone calls are possible, but they're recorded and there's
yeah,
no confidentiality.
yeah,
Sometimes I do visit the clients in person, though, especially if it seems like there's some sort of maybe learning impairment or just some really important issue that face to face we need to sit down and talk about this. That often comes up if there's a decision about whether to continue with the appeal or to withdraw the appeal, and what are the implications of that, and thinking that through. But yeah, it's definitely less. I don't really have a lot of foot traffic. I would say, particularly with clients for the appeals, they're all across the state. I
yes,
have people
yeah,
that
that's
are,
hard. Yeah, that's definitely hard.
yeah, I mean, from Murphy to Manio, it's just you never know where they're going to come from, and so
Yeah,
we don't.
that's super cool.
Yeah, yeah.
Well, to kind of dive like into the issues, because I know we've got a lot to unpack, I'll kind of just maybe, I think a lot of times I learn best from my mistakes. That's just the
Don't we all?
school of hard knocks. That's the easiest place to get a degree. So tell me like what the most common mistakes that you see from trial lawyers in preserving issues for appeal, or other mistakes as an appellate lawyer that you see made at the trial level.
Yes. And I'll start by saying, obviously, no one is perfect, right? We all make mistakes. We all learn from our mistakes. Um, so, but doing this for a number of years now, and talking to other appellate lawyers as well, there are some things that we see more frequently, and so I think maybe presenting it kind of in a chronological way, like over the course of a trial, from the beginning to end, is perhaps a helpful way to think about um, you know, issue spotting and
Yes.
error um, improvement. So the first thing I think is always move for complete recordation if you're going to be having a trial. The court reporter is not required to type down everything that everyone says, particularly opening statements, closing arguments, bench conferences, jury selection. And a lot of times those are areas that are ripe for appeal, particularly if you have Batson issues, if you've got improper closing arguments, maybe there's something significant that happened, during a bench conference. If we don't have that on the record, we can't do anything with that on appeal. And so you're really missing out on a lot of opportunities for the appellate attorney to raise an issue on appeal if you don't ask for complete recordation. And it's a very simple motion, and the court has to grant it. You're guaranteed to win that one. So there's no reason not to raise that
Yeah.
and move for it
Yeah,
under the statute.
that's a great one. I don't think I've ever asked for that. So that's a really powerful thing to know. So
Absolutely. And so sometimes issues on appeal, can be, for instance, like a Harbison error. So if the defense attorney, inadvertently makes an argument that concedes the client's guilt during closing argument without the client's informed consent, that's an automatic reversal. Now, I know defense attorneys, are careful and don't want to do that unless they have their client's consent, and it's a strategic move. But, for the client's sake, if that is an issue that they want to appeal, we need to have the defense closing arguments recorded, by the court reporter. So, yes, moving for complete recordation, just make the motion. It really will put you in the good graces of the appellate lawyer.
yeah, I love that. And before maybe you move on to your next point, I think I'm just gonna maybe point this out because this is one of the things that we had talked about in our kind of prep phone call a couple weeks back. But just realizing that again, everybody makes mistakes. All of us make mistakes, and I think that there's somewhat of a tension that we had kind of discussed about trial lawyers being nervous about things going up on appeal, because it's like, am I going to be kind of called out for making a mistake? Am I going to be reprimanded in some way? And so I think a lot of it is just recognizing that, again, we all make mistakes. That's just part of the nature of being human. I mean, that's just part of it. And so I think open dialogue with appellate counsel can really help on some of those things. I think that's one of the things that we had really kind of talked through. So again, maybe that's a better point for later in the conversation, but I just didn't want to miss that. So
No, absolutely. And we can revisit it later on, but you're right. And I would say more often than not, the subject of an appeal is not going to be the defense attorney's performance. It's really going to be about evidentiary issues that were raised and hopefully objected to, that were improper closing arguments by the state, improper rulings, motions to suppress, judicial action. That's usually what we're looking at for appeal. It's not necessarily, hey, let's pick apart the defense attorney.
Yes.
That's not, I think, what really appeals are about. So I think demystifying that misconception is really important, because trial attorneys and appellate lawyers, can really work together to favor the client and their interests. And I think even once the appeal, once the trial is over, the trial lawyer still has an ethical obligation to try and, with a duty of loyalty to the client to help them. So keeping that in mind is important too.
Yeah, I love that. Yeah, that's a great point to bring out as well. So yeah, sorry to derail you. So what other kind of common mistakes do you see at the trial level?
So I think after the complete recordation, another common mistake we see is not raising specific enough objections. Okay, you need to cite the statute, cite the rule of evidence, and constitutionalize your objections. If you don't, say confrontation clause violation, Sixth Amendment, Your Honor, in addition to hearsay, we don't get to raise that issue on appeal. And constitutional violations, you might think, well, sure, shouldn't the Court of Appeals be interested? But they are not interested if it's not preserved. And so it's really important. And you don't need to go into immense detail with every objection about case law and, a constitutional history. It just needs to be cite the statute, cite the rule, and constitutionalize it, Fifth Amendment, Sixth Amendment, whatever it is. And so that way we have that opportunity to continue to raise that, and it's not waived for the appellate lawyer.
Yeah, I think that's really important. Even from like a trial perspective, and there's certain times where you maybe kind of like want to make a show to the jury of an objection, and other times where you maybe just really want to like put it on the record, but really are not trying to kind of like have the objection influence the jury. But obviously hearing objections from either side and the ruling really, I do think plays like a role in how the jury is interpreting the evidence. But one thing that I think is so powerful with any time that you can kind of like insert case law for your argument, it just shows a kind of superior level of mastery. So the state, most of the time, if the state is making an objection on their end, they will not basically cite the basis for the objection. And maybe that's somewhat like maybe too generalized. I have heard, prosecutors say an objection to relevancy or prejudicial, whatever it might be. But in terms of like citing specific, sections of the Constitution or a statute or rule of evidence, that to me is really powerful because it shows a mastery of the law. So even if you're not really making a show of the objection itself, just including that, I kind of, always tell our lawyers at the office to do the same when it comes to DWI sentencing factors. Instead of just saying, here are the factors in mitigation, point to the section of the statute for the mitigating factors, which most of the judges know like the back of their hand, but it conveys to your client a mastery of the law that is otherwise kind of getting lost. And it's the same thing with the jury. They're like, okay, this person is objecting based on all of these different, kind of legal grounds. And over here, you're just hearing the word objection. Maybe they just don't like the evidence that's coming in. So I think that there is some value even in just kind of like the show to the jury of doing that, in addition to obviously preserving the issues.
Yeah, and I think it shows to the client and the jury that you're prepared. I think you're as a trial lawyer know this better than I do. But when you're thinking about preparing your case, you're thinking about what testimony is going to come in. You want to try and anticipate what the evidentiary issues are going to be. Where are those battles going to be fought, and what challenges do I intend to make, and have them written down. Have the rules, write them down. Write the constitutional provisions you want to base your objection on. Have that written down so you don't have to rely on your memory spontaneously.
Yes.
On the fly. So that way you're prepared, and that way the proper objection is made, and that way you're good to go if an appeal is entered, and the appellate lawyer will thank you for doing that.
And I also do think that, in addition to those reasons, even just communicating to the judge, I think judges sometimes don't know what the grounds for objection is. And they also don't want to influence the jury with like a back and forth question in real time about like what the grounds of your objection are. So again, I think that maybe we assume on the trial side of things the judge knows what the grounds for my objection is, even if I don't state it. But having kind of talked with enough both district court level judges and superior court level judges, in district court, they're much more quick to ask, what's the grounds for your objection? Because they just don't know like what it is that you're basing that on. In superior court, I think there actually is a little bit more hesitancy to that, because the judge is kind of concerned with influencing the jury based on like what they're trying to draw out of counsel. And so, I just think, again, beyond just the practical reasons, appellate reasons, it's like the judge really may not have any clue why you're objecting to evidence if you don't tell them. So
Yeah, and I think a good point to think about is, it sort of comes from the discussion you just had, is if the judge wants to be heard, your party wants to be heard outside the presence of the jury, wants to dig into the nature of the objection a little more. Even if the judge overrules you outside the presence of the jury and then brings the jury back in, you still need to object when that testimony comes up, and the witness is back on the stand, because the issue won't be preserved if you don't object in the presence of the jury. So always keep that in mind. It's a good point for trial lawyers. It's got to be done in the presence of the jury. Even if you just made your argument and the judge said, overruled, bring the jury back in, the witness is going to get on the stand, and then the witness gives the problematic testimony, object again. It might seem like redundant, but it's got to be done in the presence of the jury, or the Court of Appeals will hold it against you and they won't review the issue.
Yeah, no, I think that's a great reminder on that front. Yeah, any other kind of big picture mistakes that you see?
Yeah, I think another common thing that I see is, and I understand why this might happen, but it's important to still address it, is not objecting during closing arguments. So let's say the state, it's usually the state's making its closing argument, and maybe there's something improper. Maybe they're arguing facts, not evidence. Maybe it's just inflammatory, or maybe they keep giving their personal opinion about the guilt of the defendant. There's a statute that specifically says you can't say these things in closing argument. And if you don't object to them, the appellate lawyer is stuck with this almost impossibly difficult burden of trying to prove that the closing argument was so egregious that the trial court should have intervened, what they call ex mero motu, on its own. And our appellate courts have made that such a high bar that they routinely will say, yeah, technically they shouldn't have said that, but the trial lawyer didn't object, so they can't actually prove that there was, a reversible error. So I understand if you're the trial lawyer, you don't want to look like a jerk to the jury. I'm interrupting the DA's closing argument. I'm sorry, ladies and gentlemen. I can see there's a tension, but I think trial lawyers need to think, my client's interest in preserving this issue, trying to protect something for an appeal, if it seems out of line, I think you just got to make the objection. And I think the jury understands,
Yes.
You're doing your job. That's just what you're there for, to represent your client. So don't be afraid. Don't be hesitant to get up and make that objection to something in closing argument.
There
really
can definitely
important.
be some strategic value to that as well. I mean, I think that anytime that I've received an objection in closing argument, I really don't think there's ever been one that's been like sustained, but it threw me off my game. It was like I had to kind of like pause and then kind of get like back on script. And so again, without like throwing your pencil on the floor and screaming objection and coming off as just a jerk. Again, I think if you're doing it in like a calm, collected way and just again pointing to a specific statute, here is the basis, the grounds for the objection, that really can throw the prosecutor off in terms of being interrupted during closing. And I've seen some attorneys do a really good job, at both district court and in superior court, kind of like throwing the state off their game with objections in closing. And again, there's that balance between, again, not wanting to appear appear like a jerk, but the more like collected you are and just very black and white about this thing that you're passing along to the jury. And if one of those objections gets upheld, which again may be a long shot, but if one of those objections gets upheld or there's some sort of warning given by the judge, that will throw a lot of doubt on the jury in terms of buying into whatever the prosecutor is saying. So I really do think it can be a very strategic play in addition to obviously being helpful on the appeals front.
That's a great point. I think if you can point out specifically, hey, this DA is arguing facts, not in evidence. This witness never said that. You look like you have a mastery of the testimony, and I think it impacts the credibility of the prosecutor at a critical point in the trial, in which the jury is clearly in a important moment formulating their opinion about the case.
Yeah, 100%. Yeah, I think that's really powerful. What other mistakes?
Yeah. So I think, so not entering let's talk about motions to dismiss. There is, a tendency, I think I've seen among trial lawyers to sometimes fail to move for both insufficient evidence and for variance, variance between the charging documents and the evidence presented, and make sure you argue both, and it's as simple as, Your Honor, we move to dismiss all charges for insufficiency of the evidence and for fatal variance. Then if there are multiple charges and maybe you just want to talk specifically about certain issues pertaining to some of the charges, that's fine. You can get specific about some of them, but always make sure, I think, you open and close with, we're moving to dismiss all charges for insufficient evidence and for fatal variance. And that way, that's all you got to do to preserve all issues relating to sufficiency and variance for the appellate lawyer. Sometimes the trial attorneys will say, Your Honor, we're going to make a motion to dismiss, but I'm going to kind of limit it to, this particular charge. Don't do that, because it prevents us from addressing the other charges and on an appeal on a sufficiency issue. So fine to talk specifics about some of them, but always make sure you open and close that motion to dismiss with make sure you're clear. It's all charges, for sufficiency and fatal variance.
Yeah, I love that. I think that in terms of just like real life example of that, and I don't have this at the appellate level, but there have been multiple times at the district court level on a DWI case that's been the vast majority of my trials where, I'm arguing a motion to dismiss as to the DWI, and the judge is like, well, I find that the state has met its burden as to that, but not so much on the no operator's license. And I didn't even bring that up, and so it's just kind of like, oh, probably should be paying attention to some of this other stuff. So I mean, definitely the judges on their own have done that at the district court level. So I love like the suggestion to make sure you're not missing that.
Yeah. And so another thing that's sort of I think a natural segue to talk about next is notice of appeal. You've given it your all trial, but the jury just came back with the judge came back with a different verdict than you were hoping for. There's two ways to give notice of appeal to the Court of Appeals. The easiest way is just to give it in open court immediately upon judgment. And it's as simple as, Your Honor, we give notice of appeal. That's it. We give notice of appeal. If the client is indigent, you can ask for the appellate defender to be appointed, but as a matter of course, once you give notice of appeal and the appellate entries are entered, the court will find the defendant indigent if they are. The other way, sort of the less preferred way, in my opinion, because there are pitfalls, is a written notice of appeal. And a written notice of appeal has to be filed within 14 days of when judgment is entered. And it has to be very specific under the Rule 4 of the appellate rules. And it's got to specify the party appealing, the judgment that they're appealing, say that you're appealing to the North Carolina Court of Appeals, even though that's obvious, it has to say that. It's got to be signed, it's got to be served, it's got to be filed. You got to make sure you check all those boxes. And I've seen a lot of appeals where they leave one or more of those things off, and that makes our job on appeal that much more cumbersome because the right to appeal is lost. And now we're having to petition for certiorari to ask the Court of Appeals to please, let this client have their appeal, even though they filed a defective notice. So my advice is don't get into the trap of having to file or enter a written notice of appeal. If you think there's going to be an appeal, just give notice of appeal in open court. I understand that maybe you haven't made that decision with your client. Maybe they weren't sure if they wanted to appeal right away. So maybe it is a week out when they finally decide, hey, I think I want to do that appeal. Just make sure you check Rule 4. The appellate defender has a great website, the ncappellategedefender.org. They have sample written motions on there. They've got sample notices of appeal. You don't need to reinvent the wheel. They've already done it. Go download their sample and just plug in your
that's
information.
A great resource. Yeah, thanks for sharing that.
Mm-hmm. I think another issue that we should talk about, Jake, is motions to suppress specifically, for guilty pleas and for trials, because a lot of times in guilty plea cases, maybe you had a great motion to suppress, but that's really all there was. And if you lose the motion,
yes,
there's going to be a guilty plea, but maybe you want to preserve that issue for an appeal. Maybe you can get a reversal. It's really important to make sure you take the proper steps to preserve that for your client. And so, it's kind of like a two-step dance in my mind.
This is something I'm glad you're talking about, because this has always made me super nervous when I'm filling out the plea transcript after a motion to suppress that is not denied by the judge. I'm always like, which questions on here do we have to specifically again state we are not giving up on the motion to suppress? So yeah, love this.
Yeah, and it really is straightforward. And so I think I want to try and hopefully I can alleviate some of those fears and anxieties among the defense bar. But you got to give notice of your intent to appeal to the prosecutor. And that sounds tricky, but it's as straightforward as in that box on the transcript of plea, where terms of plea agreement, just put in there, defendant reserves the right to appeal the denial of their motion to suppress. That's the notice. That's all you got to say is defendant reserves the right to appeal the denial of their motion to suppress. And then that's
in the box you're talking about in terms of the terms of the plea agreement, and that kind of catch
where it gets where all the information gets typed in, what the specific terms are. So it's not one of the numbered questions, where you just check yes or no. It actually goes in that box, that window where the state or you are typing in what the specific terms are. So just somewhere in that box, make sure you have in there, defendant reserves the right to appeal the denial of their motion to suppress.
Okay.
And if you do that, you have satisfied, the first step of the two-step dance. Step 2 is to make sure that you give notice of appeal from the judgment when judgment is entered. Okay. So when after your client is sentenced, the guilty plea has been accepted, judgment is entered, right there in open court. Just say, Your Honor, we give notice of appeal. As we've already indicated, defendant intends to appeal the denial of their motion to suppress. It's in the plea transcript. But you just got to do both of those things. Put it in the plea transcript expressly. And then once judgment is entered in open court, before you pack up and leave, just say, Your Honor, on the record, we give notice of appeal. And that's it. You just got to do those two things. And you have preserved the client's right to appeal their motion to suppress.
Yeah, that's awesome. That is a good demystification, because I feel like anytime I've had that issue in the past, I have gone out of my way to give a lot of verbiage as the plea is going on, and it probably sounds a little crazy from the judge's perspective of like, what is this guy talking about? So
Yeah, and really just one line is all it needs to be in the transcript of plea. Because all you're doing is just putting it on record that we're reserving that right, you know, and it doesn't need to be. You don't need to get into the specific argument
yeah,
about
see,
why
that's for
what
some
Fourth
reason
Amendment issue
I don't
you're
know where
saving.
that like came from,
Don't
but
cite any cases.
for some reason it was in my brain that you had to cite specifically what the grounds of your appeal to the motion to suppress were. So I had this like language of any constitutional issues, statutory issues, case law. It's just like this total ridiculous.
Yeah,
So yeah.
yeah, and honestly, it's better to keep it more broad. So that way the state can't potentially argue that somehow you've hemmed yourself in as to what issues could be raised on appeal. I don't really think they could do that, but I wouldn't want to give them that opening. I'm
Yes.
just saying, hey, we intend to reserve, the right to appeal to denial of the motion to suppress that's perfect. That's all it's got to be. And then just, after that guilty plea is tendered in court and the judgment is entered, sentence is pronounced, just before you make sure you say right then and there, we intend to, we give notice of appeal, Your Honor, and that way you've done everything you need to do. It's just those two critical steps. Now, there was a North Carolina Supreme Court case that came out earlier this year, Jonas. It came out in May, State versus Jonas, and our Supreme Court held you don't need to give notice to the prosecution that you intend to deny or intend to appeal the denial of a motion to suppress in an open plea or just a straight plea.
Okay.
And so that way, if there is no plea transcript or whatever, you still you don't need to get that note. You still need to get notice of appeal, once judgment is entered and before you leave court, still say, we give notice of appeal, but you don't have to formalize or memorialize anything more specific about a motion to suppress in an open plea context.
That's very helpful as well. I think I think a fair amount of the ones that I've had in the past, there wasn't any true plea agreement after a denial of the motion to suppress because of the fact that we had already kind of passed our plea offer dates.
Window.
And so
Yeah.
so it's just like, we're gonna push this issue and this is the kind of sole item that we have. So that's interesting.
Yeah, and I'll close on motions to suppress with one more point, which is, let's say you have a motion to suppress that's denied, but then you don't have a guilty plea. Instead, you're going to trial. Make sure that even though you moved to suppress and it was denied, you still have to object to the evidence at trial that was the subject of the motion to suppress. As soon as it comes in, you've got to object. So whether it's maybe you're challenging the defendant's statements as a Miranda issue, object as soon as those statements are brought up. Maybe it's evidence that was seized without a warrant. As soon as that evidence is introduced, object. And that way you've done what you need to do to preserve the issue in terms of raising it on appeal for whether or not the motion to suppress was properly denied.
Is there any kind of issue, because in terms of like trying to get like a standing objection, or is there kind of best practice for, if you have the prosecution repeatedly talking about some issue that you've raised in a motion to suppress and has been denied, like how many times do you does the judge have the power to cut that off? Do you after a certain amount of times, does the Court of Appeals say this issue has been preserved? What are best practice, or do you just object after literally every question? What's the best practice on that?
So there's cases out there on this, and whether there's a standing objection, to a line of questioning, and the case law recognizes that there is. So, but I think you have to make that objection timely.
Okay.
The first time and specific, and that way it's clear to the line of questioning and subsequent questioning about this topic that you have a problem with, that you have an objection to.
Okay.
And that way I think it's the Court of Appeals understands that what you're encompassing by your objection. If the line of questioning changes even a little bit, or they start getting off into a little bit different territory, I think I would object again,
Okay.
just to be, out of a caution. But if it's just literally the same topic over and over and over again, I mean, you could object on other grounds that they're asking
Yeah.
a question. Okay.
No,
But
I think that's helpful, because I do think, again, in terms of the kind of perception of the jury, if you're doing that for preservation, or objection based on our previous argument on this front, judge, whatever it might be, and that's a one time thing, that's different, I feel like, in the jury's mind, than like you are somewhat adamant about trying to keep this evidence out and you just continually are getting overruled. The jury's like, maybe this is really important, like, almost kind of like draws a false
right,
kind of like,
significance.
yeah, significance. Exactly. Yeah.
Yeah, and also you might annoy the jury.
Yeah, that's
So,
true. Yeah.
yeah,
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 that's
you want
true.
them to like you too. But yeah, but protecting your clients' rights is important. And so, but yes, good point. About standing objections. Um, it's important to just make it clear, make it specific, and then if it starts to deviate a little bit, in terms of the questions being asked, just object. Yeah.
Well, yeah, no, great points. Anything else in terms of common mistakes that you are kind of seeing on the appellate side of things?
Um, if one of the things that comes to mind is if you're requesting special jury instructions, even if it's just a modification to the pattern instruction, it's got to be in writing. You can't just mention during the charge conference verbally or orally, "Hey, Your Honor, can we change this pattern instruction to tweak the wording?" Or, "I want an instruction, a custom instruction. I'm going to cite some case law, Your Honor, but I don't have a specific written proposed jury instruction for you." That's not good enough. You literally have to hand them a proposed instruction in writing in
Okay.
order for that to be raised as an issue for appeal, to be preserved for appeal.
Yeah, that's powerful. Definitely have had, requested an Aaron Simmons instruction a number of times in closing, and sometimes with success, sometimes not. But that's I think I stole my verbiage from Bill Powers, or he passed that along, and so that's definitely been something that I also think it gives more credence when you actually have something in writing, as opposed to really not having anything to
Yeah, well,
offer
you
to the
look
court.
prepared.
Yeah.
You look prepared.
Yeah.
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 You've put some thought into it. Maybe you have some cases you can cite that to support the instruction. So yeah, those are the main things I would say that I see.
Yeah, no,
So
that's super helpful, and a lot of great points. I think we probably in terms of like the trial side of things, think of post-conviction relief primarily in terms of appeal. But obviously you guys use other types of relief to kind of maybe get to the same end result, or something different. So what other types of post conviction relief exist, and when are kind of each the most effective?
yeah, so obviously you've got motions for appropriate relief, and there's the statutes sort of lay out two different kinds at different time frames. So there's the 10-day MARs, that I think are more commonly filed by trial lawyers, frankly, who
Yes. Yeah.
hey, there was an issue that happened at sentencing. This guy's calculation was incorrect or something, and you catch it within 10 days. And so you file that 10-day MAR, and maybe the state consents. It was obvious, it was apparent, but no one just caught it for some reason. There's 10-day MARs. And then you also have MARs that can be filed at any time after conviction. And those are usually your constitutional issues that weren't raised on appeal, couldn't have been raised on appeal. They can be jurisdictional issues. And so, usually those follow a direct appeal. But sometimes, particularly if it's a guilty plea case and it doesn't appear to be an appellate issue, sometimes the MAR is the first thing that actually gets pursued. It might be years later, Maybe they just never did a direct appeal, but they're very different processes than a direct appeal. There is an interesting, you can raise an MAR on direct appeal, and sometimes that's helpful, where the trial lawyer and the appellate lawyer can actually collaborate, I think, in this space to raise an issue on an MAR on direct appeal. So for example, I had a case where there was an indication in the record, in the transcript, of a juror coming into the courtroom during the charge conference when none of the jurors were supposed to be in the courtroom. And, the transcript said something like, the juror 8 entered the courtroom, and the judge said something like, there's a juror, can you just somebody make sure that they leave or something like that. But then there was no indication whether they ever left or not from the record. I couldn't tell.
Right.
So I raised an issue on appeal that this was improper, that they were potentially exposed to information about the defendant and their prior record that they shouldn't have been exposed to, and that it compromised their right to a fair trial and to a unanimous verdict because one juror now had more information about the case than the other jurors. And what ended up happening was the Court of Appeals dismissed the issue because they said, well, we don't have any more information. We don't have any affidavits from the lawyers or from any parties that were in the courtroom as to whether this person stayed or not. And so that's a learning moment for me where I could have talked to the trial lawyer and said, hey,
Yes.
do you remember this happening?
Yeah.
Like, if they stayed, would you sign an affidavit, like saying that this is what happened? And we can actually file that on direct appeal alongside the brief as an MAR. So sometimes
that's really a great story.
Yeah, and so that was an opportunity that could have been pursued better on my end. But I think trial lawyers and appellate counsel can really, if there's things that just aren't obvious from the record, things that maybe there was a conference in chambers. What was talked about? I don't know what was said. What was said, or was there something that just I'm not going to know from just the four corners of the transcript or the court file that this was really problematic or really rubbed you the wrong way as the trial counsel. Let's talk about that because I might not otherwise know unless you tell me. So there's space for us to work together, to protect the client's interests.
Yeah, I think that's really powerful. I mean, there's been a couple of times, and I don't know if this was just like standard operating procedure for the appellate defender's office, and then I'm sure that you did this with our shared case. But the appellate defenders on several occasions reached out and said, hey, would love to kind of get a sense of what issues are going on. It's got to be like a huge kind of shot in the dark in terms of receiving this notice of appeal that literally just says, appealing everything. And so good luck finding in this, 500-page transcript, like the one area that was actually at issue.
We'll find it. That's our job. But no, you're right. You're absolutely right. It helps to have a lead, to have someone go ahead and have that initial conversation. Like, what bothered you? What did you think the issues were? Go ahead and bring my attention to them so that I know to be on the lookout for them, but I'll be looking at everything. But yeah, absolutely. That's one of the limitations of direct appeal is you are stuck with this limited universe of,
yes,
is it on the record? Is it literally in the transcript or in a court document that's in the file? Because otherwise, if it's not within those parameters, there's not much I can do with it on direct appeal. But I can potentially raise it in a motion for appropriate relief where there's a little less restrictions in terms of, how much space you can operate within and what issues you can raise. And so thinking about, whether there's a proper venue, on appeal in the Court of Appeals to raise that is important.
Yeah, I think that's so helpful. I mean, I think anything that we can do to kind of, again, collectively go to bat for our client, that kind of communication between trial counsel and appellate counsel is incredibly helpful for the client's purposes, but I've also learned a lot of things through talking to the appellate defender about a case that I tried, because they've given, some of these same suggestions. And then also like maybe particular, suggestions about the case itself. Sometimes like because I've asked them to do that, and then sometimes just on their own saying, here's kind of like the issue and here's how we're framing it. Do you have some feedback on that? And then obviously like, this is the area that we're focusing on. Can you explain a little bit more about how this, objection kind of was raised, or again, like about what the bench conference was about in this particular area. So I just think that communication is so helpful. And again, I think this is another place to dissuade that idea that, again, maybe even like appellate defense counsel is out to get like a trial lawyer. Like that phone call, generally speaking, is very much informational. I've never had anybody that's been like, here, your license is on the line.
No, and frankly, ineffective assistance of counsel, just the elephant in the room here, is not really an issue on direct appeal. It's not something. It's frankly, because it requires so much information outside the record to raise, that the Court of Appeals generally is just not interested in actually giving a ruling on it. Sometimes it gets raised, if there's something like there was an obvious motion to suppress, or there was no reason not to object to this really prejudicial testimony, you should have done it. That might get raised as like an in the alternative argument.
Yes. Yeah.
But for the appellate lawyer's purpose, that's really only for our preserving it for future litigation. So maybe if the client doesn't get relief on appeal and they think, well, maybe I need to pursue a motion for appropriate relief, the appellate lawyer has done their job of preserving an issue. So that way the state can't say in post-conviction on a motion for appropriate relief, hey, you should have raised this issue on appeal, you didn't, and now you're barred from using it in an MAR. So we're just kind of doing our job to preserve issues just as much as the trial lawyer is doing their job by preserving issues for the appeal. But more often than not, on direct appeal, what we're interested in, where we see a lot of area for, potential relief, or a lot of times it's jury instruction issues, technical things like that, sentencing errors. There used to be jurisdictional problems, but that's kind of going away now with the Supreme Court after their decision in Singleton. So indictment challenges are really kind of becoming less of a thing, but still there's still, I think, issues to be had there, particularly if they're very vague. They're not giving specific notice, of what the actual charge is. But I think the days of saying, hey, Your Honor, they forgot to put, ink after Walmart in the indictment, and it's a fatal defect because we don't know if Walmart can own property, those are gone. We used to love those on appeal, but I think those days are over. But anyhow, yes. The integrity of the conviction is what we're concerned about.
Yes,
that's what we're after. It's not to get trial counsel. It's to make sure that the defendant got a fair trial, and usually that has to do with other things besides defense counsel's representation.
Yeah, that's huge. And again, I've learned a lot from speaking with appellate defenders about good things to be raising, good ways to preserve issues. So I think that there's a lot to be learned from those conversations as well. As a trial lawyer, I think one of the kind of thought processes is like, we're literally, we're on a misdemeanor case, like going through district court, and then obviously through like a long process, potentially in Superior Court on a more serious case. You're going through this long process of discovery, and then consideration of a plea offer, and then suppression motions and other motions, and then finally through trial. And I feel like kind of you get to this point at the end when there's a judgment that has been entered. It's like, I'm finally done. Okay, like what representation has ended. But in terms of like having a meaningful conversation about appeal, what are some best practices that you have in terms of helping a client determine whether an appeal is a good next step? And if there's a legal issue that is at play, is it helpful to reach out to kind of like somebody that handles criminal appeals from the defense side of things to consider whether or not this would be like a good issue to raise for appeal, specifically on the facts of the case? Like, obviously we want to do our best to not kind of create bad case law. And so is there any kind of guidance that we can give to clients, or kind of steps that we can take to make sure that we're not, appealing cases that are kind of frivolous, not frivolous, but going to, potentially cause kind of like damaging case law?
Yeah, no, it's a great question. I think we have to say first that it's the client's decision whether to appeal or not.
Yes.
Ultimately, whether to plea that's their call. Whether to appeal, that's their call. Even if we think you're gonna lose, or that could be bad precedent potentially, at the end of the day, that's their call, and we have to honor that. But I do think that trial counsel has a duty to advise the client about, what do you want to get? What is it you're hoping to get? If you've got a good result, maybe you got a good plea, even though your motion to suppress was denied. Do you really want to appeal and potentially blow up that plea and win the battle of the appeal, but lose the war on the case and wind up with a harsher sentence? If for some reason your case comes back and the DA says, "I'm sorry, we had a deal the last time, but you reneged and it's blown up, and I don't have to offer you that deal anymore. And now we're going to trial,
Yes.
and you're facing a harsher sentence." So, strategic questions, particularly in plea cases, guilty pleas, are really important, because the law doesn't provide protection to defendants if they win their appeal and they come back and you're back at step one. You don't want to wind up worse off. So I think advising the client about the risks of an appeal, particularly in a guilty plea context, that's really important. In terms of, if it's a trial, and they got a long sentence, and so it seems like you might as well appeal, no harm. I would just, go ahead and give notice of appeal. If it turns out that the client wants to withdraw later on, that's fine. The appellate lawyer can withdraw the appeal, but just put the wheels in motion and let that get sorted out down the line. In terms of whether you're going to create bad precedent, you could talk to the appellate defender's office. You could talk to folks like myself. What's the case law on this? Do we even think we have a good issue? I thought this was going to be a good issue for appeal, but you're telling me that the precedent is all against me. Maybe the client doesn't want to pay to hire a new appellate lawyer if they're not indigent to pursue what's likely to be a losing appeal. So I think as long as you're doing that within your time frame that we talked about before, it's fine if you give notice of appeal in open court. There's no harm done. But if you're talking with a client, day 12, day 13, you've only got 14 days to file that written notice of appeal. So these are conversations that need to be had in a pretty quick and timely fashion after the judgment is ended.
Yeah, that's super, super helpful. I think, kind of along that same lines, in terms of just considerations, I don't really have like a good estimation of time frame from, an appeal to, a decision being rendered by the Court of Appeals. And obviously that could then be potentially appealed up to the Supreme Court by, either side. But what is kind of do you have like a kind of typical time frame that you talk to with clients? Because I think that'd just be helpful for us as well to kind of be including that in that kind of advisement conversation.
Yeah, it takes forever to answer your question. Yeah. I typically tell my clients it could be anywhere from a year to 2 years, year and a half, before you get a decision. Appeals are very deadline driven. 30 days for this, 45 days for that, but parties get extensions.
Yes.
We can get extensions to file briefs, extensions to file records, proposed records. And then once the Court of Appeals gets it, they'll set it on the calendar. Most of the time there's not going to be oral argument. They used to do a little bit more oral argument, but nowadays sometimes it's 10% of cases, or maybe no
Yeah.
cases at all on a calendar of 12 have got oral argument. And I think that's just a function of just the number of appeals, the sheer volume of
Yes.
appeals.
Yeah.
Um, so, but then once your case is quote unquote heard, either with or without oral argument, it kind of goes into a black box. We don't know when the decision's coming out. We don't have a way of speeding it up. I mean, occasionally, if there are grounds for a motion to expedite an appeal, maybe your client is coming up on the end of their sentence and they're going to have done the whole time before the decision comes out. Maybe there's a decision to expedite, but even those, they don't have to honor that, or you don't even know how much more expedited it's going to be. So you just have to wait. So yeah, in terms of just a court of appeals case, I think you're looking at usually anywhere from a year and a half to, on the long end, 2 years. And then, like you said, is there going to be future litigation at the Supreme Court? The North Carolina Supreme Court. That's going to, that could draw it out another 3 to 6 months, potentially longer, depending on what's going on there. It takes a while.
Just to kind of follow up on that question as well, again, in terms of just advising somebody that may be getting ready to serve an active sentence about their appeal, is there any kind of specific strategy for, requesting like a stay of sentencing for, somebody that's looking at, a year to maybe 2 years of, a year to 2 year sentence, and, likely by the time the appeal is decided, then that whole sentence, or substantial portion of that, is there anything you can do on the front end that from a trial counsel perspective, or is that more of like an appellate level issue?
No, I think so. There are appeal bonds, and it's kind of like a bond that's set at the beginning of a trial level case, where you can move for an appeal bond. You could do it in open court after giving notice of appeal. The court may address the bond right then and there, and whether there's going to be release pending appeal. So I think being prepared to make an argument as to why the client should be given an appeal bond is probably something you need to have in your back pocket if you know in advance you're going to be giving notice of appeal. Has the client have they had any failure to appears? Do they always come to court? Do they have a stake in the community? They're not going anywhere. That's those common arguments that we make at bond hearings apply just as much to. But also, I think the argument like you just made, well, Your Honor, they're going to serve. They have a 12-month sentence. They're going to have done. Principles of equity require that they just not have to do their time while their appeal is still pending. But unfortunately, it is something that we see where people end up doing their whole sentence before their appeal even comes out. So that is a thing.
Yes.
Yeah. Another it's the thing that comes to mind though, Jake, is probation and probation appeals. So probation is stayed automatically, and special probation is stayed upon giving notice of appeal. So if there is, if the client's supposed to do some time as a split sentence or as part of the term of special probation, they shouldn't do that under the 15A 1451. That's all stayed. And usually that happens automatically. The probation officer understands that once you've entered notice of appeal, that all gets put on hold. But I've had cases where they don't really recognize that right away, and then we have to try and get the client out of the jail, and it's just the whole thing. So trying to get ahead of that,
that's helpful
on the front end, is really important.
Yeah, that's super helpful. Well, I mean, obviously, like a ton of information that you've shared. I mean, I think this is a really good, like, kind of 30,000 foot view of kind of like best practices for us on the trial end of things. If there was any kind of like one point that you could drive home to a trial lawyer about a kind of appellate considerations, what would that be on your end, Warren?
Move for complete recordation and make specific objections.
Yeah, I love that.
Just tee us up for success. If you don't raise the issue, if it's not in the record, it's waived. We can't do anything with it,
Yeah,
just
well, I mean, just going back, to your comment a few minutes ago about just operating in that closed world. It's like, if it's going to be a closed environment, at least have as much in that closed environment as possible. So again, just, certainly a change on my end, because as I said, I don't think I've ever made a motion for complete recordation. I know our public defender's office does that here in Buncombe County, kind of like as a matter of course, and I never knew why they did that. So it's just, yeah, super
yeah,
helpful they did
always
that.
do that. Yeah, yeah. And any pretrial motions that are important, if there's discovery issues, or you think there's not compliance with discovery, or if there's a motion to sever, or anything that's really important, just file a written motion, and that way we can put that in the record on appeal. It gives us more opportunity to make more arguments, especially if you put in your motion some constitutional citations or some case law. That just further enables us to say that this is preserved, and now the Court of Appeals can properly weigh in. So yeah, give us as much room as we can in that limited universe, and you'll have done your client a favor, and you'll have done us a favor.
Yeah, love that. Well, I know that you are happy to kind of, talk with anybody that has a potential criminal appeal issue, or lawyers that are trying to kind of like maybe walk through a motion for appropriate relief, post-conviction circumstance from Superior Court. So how can defense lawyers reach out to you?
Yeah, absolutely. So happy to talk about any of those subjects. I think the easiest thing to do is just go to our website, which is Hynson, Hynson law.com. You'll see our phone number, address. My email is on there. So Hynson Law, Hynson law.com. And happy to talk with folks. Again, we handle cases all across the state. And post-conviction, as well as direct appeals and criminal cases. Always happy to brainstorm and to help out where we can.
Love it, Warren. Well, thank you very much for coming on and sharing your wisdom with the audience, and look forward to talking with you again soon.
Awesome, Jake. I really appreciate you having me.